2A2, to introduce evidence of an aggressive character, it must be in relation to a homicide case. We have a victim who is alive. He is able to cross-examine her. Any backstory or statements, he's going to be able to ask on direct if his client chooses to testify. So in relation to cases where it does come through, homicide cases alone, this is not admissible for this purpose. This is not a homicide case. This is a domestic violence case. And then if the defendant chooses to say, I'm acting in self-defense in this matter, also that's not going to come in because he's asserting other acts, evidence of deception, lie, self-harm, threat, blackmail, false claims. But he is attempting to relate this to the incident and to explain why he was letting her in, saying she didn't have permission, but then therefore saying, oh, well, I actually let her in because of other acts. While he may think that that's a material thing, it doesn't have probative value. So it doesn't necessarily have the tendency to make the self-defense claim or why he might have done that more or less probable.
Buckle up, guys. Today we're going to watch a courtroom moment where everything shifts in seconds. The prosecutor wastes no time shutting down the defense, making it crystal clear. This is not a homicide case. It's domestic violence. She argues character evidence won't come in. Self-defense doesn't apply. And any attempt to paint a bigger story would only confuse a jury. The tone is firm, controlled, and decisive.
So, and also these other acts, evidence probative value does not substantially outweigh any confusion of the issues or misleading the jury. And I would just reiterate, all of this information would mislead the jury. This would confuse the jury as to who is the person that's on trial here.
It's this evidence that I've proffered is probative to establishing to essentially affirm or confirm the position my client had taken for 8 months or so, which is to not seek her out, to not go and do anything with her of his own choosing, other than to respond and try to be helpful. That can then, he's not claiming self-defense, he's claiming this never happened. But there's a reason why these allegations have come up, because it's part of this common scheme of again, almost in a session with my client that is even talked about in some of these messages where she won't leave him alone. And there was one thing I heard from the prosecution that I don't know anything about is she said she's got 404B evidence, and I have not received any notice of that. So I'm not sure what that is, but if she's got her own kind of 404B, that would have to be noticed up to myself in the court. I have not heard anything about that.
That is correct, Your Honor, and that is not an accurate statement to the court, given the fact I did tell Mr. Feitfelski that I was going to file my own notice after the results of this hearing. He does know I was very open with him about the police reports, about the statement. I shared with him the discovery. I have emails I can present to the court, actually. So I don't appreciate that. As far as the notice, I have to give 14 days before trial, not before jury selection, not before final settlement conferences.
That's fine. I'm not trying to disparage character. I'm just saying I haven't seen anything yet. 404B 1 or 2 says a 14-day notice before trial. If trial's not going to happen for more than 14 days, I'm fine with that. But I'm just saying, I have not said anything about impugning character. And some of these, yeah, I have not received a written 404B notice. That's all I'm saying.
Here, the focus turns to credibility. The defense insists he did not know about additional charges and maintains he doesn't play games. Moments later, the prosecutor pushes back, reminding the court of prior discussions about pending charges. From the outside, this exchange feels less about paperwork and more about trust. The The tension becomes personal, and the judge listens closely as both sides subtly question each other's transparency.
But those in part are based on police reports.
All recorded statements. Yes, Your Honor.
And has defense received those, or?
Yes, I do believe he has.
I,
He can correct me if I'm wrong, but if he has not received all of those, then
I don't know what you mean by all. I have 2 police reports for these 2 cases. I received the first one after a case was filed. I received the second one after the case was filed, which I would add, I didn't even know there was a second file being opened until after I called and found out there was a warrant. So I don't know exactly what you're referring to, but if there is a specific email, I'm happy to look back at that. I never like to play, I don't play games. I just like to know what the details are. And in fairness, I try to do everything I can to keep everything above board. If there's something specific in reports, it's helpful for me to know exactly what she's pointing to, just like she wants.
Okay, then we can just ask the question. Is it something outside of the 2 police reports that he says?
not at this time, Your Honor. And as for he didn't know there were new charges, if you recall a bench conference at our last meeting, I actually asked to adjourn because we were going to review something for pending charges. Mr. Feifelsky was standing right next to me when I told the court that. So as for games, I too do not play them. And there is nothing to show that I can indicate from Mr. Feifelsky. I will file my notice timely.
Anything else, Mr. Fairfield?
Not on that issue, Judge.
I see Councilman Chambers.
At this point, the prosecution lays out explosive allegations. As an observer, you can feel the temperature in the room rise. The prosecutor reads alleged threats directly from the police report, including statements about killing the victim and pressuring her to stop the case. She emphasizes recorded jail calls and repeated attempts to interfere. The narrative shifts from legal technicalities to public safety, framing the defendant as a serious danger.
Specializes in fine foods, making fine foods, Your Honor. He's at risk of losing his job. He promises, and I know the court may be somewhat skeptical, but he promises not to make any more phone calls. He has a daughter who has medical needs, which he is hoping to gain custody of shortly in order to gain Section 8 housing, Your Honor. He would like you to consider all those matters, Your Honor. It's my understanding there's no bond. I'm just asking for a reasonable bond be set on these matters. I believe on the PPO matter, not in this court, there's a $100,000 bond already set, but I would just ask the court to please consider a reasonable bond on these 4 matters.
And Your Honor, I believe that the no bond at this time is a reasonable bond because of the allegations where he is calling the victim saying that he does not want her to proceed. He wants to send an email, a letter, a voice recording to myself. It's my understanding through all of her recordings and texts and things I've received from the prior defense counsel that she is now recanting and no longer wanting to proceed. It is not her that is proceeding on this case. It is the people of the state of Michigan, and we will continue to proceed with this case regardless if she is present or not. So that is something the defendant needs to understand. There is nothing that the victim can do at this point to stop the proceeding of this case. There are also several allegations in the police report where he has sent her email saying, "Bitch, you're dead when I see you. I'm going to blow your brains out as soon as you walk in the door, bitch. I'm going to be right there in court, bitch. That's my last time seeing you. I'm going to kill you right there. You deserve your ass beat. I will fucking murder your stupid ass, bitch." Those are in the allegations in the police report. I also have the recordings of the jail call where he stated, "When I get out, I am beating your ass." There are numerous times where he says, Please call the prosecutor, write a letter to the court. Numerous times telling her, I didn't do this. I can't believe you told them about this home invasion. I didn't break in your house. The door was unlocked. He is a danger not only to this victim, I believe to society. These charges are extremely serious. I believe he needs to be in custody because I don't think any other measures would protect this victim and or the community.
Your Honor,
Anything else?
I don't, I stand by my original argument.
With reference to the bond in this case, the court has heard the numerous allegations of this, and I understand what the people are now dealing with regard to this alleged victim in this case. But all of that, this court believes, is caused by the defendant's conduct. I'm now, after revoking his phone privileges, I don't have hope that the defendant would listen to this court, because now I have allegations that he's using used other PIN numbers to continue the conduct. And so for that reason, I think the appropriate bond is currently set at no bond, and the defendant will have his day in court. So motion for bond reduction or change in bond is denied. I will set the defendant's preliminary exam date. I'll adjourn it out, finding good cause to do so, given the withdrawal of counsel.
In the final stretch, the judge delivers a decisive blow, referencing the alleged threats and claims that the defendant continued calling despite revoked privileges. The court expresses concern about ongoing conduct. The judge states there is little confidence the defendant would comply with conditions and formally denies the bond reduction. The ruling lands with finality.